WBC 11749 of 2022 with content 6770 of 2029.
From the submissions made by Mr. Dalai, the petitioner's grievance lies on the issue that the mortgage property has been violated by the opposite party bank, which proceeded with the auction sale despite the petitioner having deposited substantial amounts towards the settlement of the loan account backed by the order of this court under its writ jurisdiction. The annual Supreme Court in catena of decisions has consistently reiterated the limitations on the exercise of writ jurisdiction by high courts in matters arising out of actions taken under the SAFESI Act. This court has followed several decisions of the Supreme Court. It is well established in light of the settled legal position and the principles reiterated in the aforementioned decisions of SAFESI Act 2002 provides a comprehensive mechanism for addressing grievances related to action taken by the banks or financial institutions. The borrower has the statutory remedy under Section 17 of the Act to challenge the bank's action, including the classification of the account as NPA. As observed in these rulings, courts have consistently held that writ petitions should not be entertained when there exists an effective alternative remedy, such as those provided under the SAFESI Act 2002. The statutory process for recovery of dues and redressal of grievances is already in place, including debt recovery tribunals and the appellate authorities which are equipped to deal with such matters. The high courts, therefore, have repeatedly been urged by the Supreme Court to exercise their discretion with greater caution and not interfere in matters where statutory remedies are available. Therefore, the petition is clearly an attempt to evade the procedural safeguards, and the petitioner is misusing the judicial process without exhausting the alternative statutory remedy provided by the Act. In the case of the petitioner who relied upon the decision in the matter of Surinder Pal Singh versus Vijay Bank, others, where the right of redemption has been allowed by the Supreme Court. In the case of the petitioner, the e-action notice was published on 12/8/2021 in the amended provision of Section 13(8), which applies to the petitioner's case. The right of redemption extinguishes on the date of the publication of the notice for public auction under Rule 9(1) of the SAFESI Security Interest Enforcement Rules 2002 is made. This means that once the auction notice is published, the borrower no longer has the right to redeem the asset by clearing the dues. The petitioner's case squarely falls within the ambit of this amended provision, as the auction notice was published and sale was conducted with SAFESI Act 2002 by the time the petitioner approached this court under the writ jurisdiction. The amended Section 13(8) therefore limits the petitioner's right of redemption to point before publication of the e-auction notice, which had already occurred in this case. The decision referred to by Mr. Dalai in the matter of Surinder Pal, giving a right of redemption being one in connection with an unamended provision, is not applicable to the present case. As far as the other decision of the Supreme Court is concerned, in Authorized Officers, State Bank of Travancore versus Matthews Casey reported in 2018-3 SEC, the Honorable Supreme Court held that it is not appropriate for the High Courts to interfere in recovery proceedings under the SAFESI Act 2002 unless exceptional circumstances warrant such interference. The SAFESI Act 2002 is to provide a speedy and effective remedy for banks and financial institutions, and judicial interference at every stage of recovery process would defeat the very object of the statute. In view of the above, the prayer of the petitioner invoking the jurisdiction of this court, being not in consonance with the fact and law, deserves no merit for consideration. A significant thing has happened in the present case. It is also incumbent upon this court to highlight the fact that the petitioner in this case is not the borrower, but the guarantor of the loan in question. This raises a significant question regarding his locus standi to challenge the e-auction cell and other proceedings initiated. As per the established legal principles, the primary responsibility for repayment of the loan lies with the borrower, while the role of the guarantor is secondary and contingent upon the borrower's default. In the present case, the borrower has not come forward to challenge the action of the bank or the auction cell. The role of a guarantor is fundamentally to provide assurance to the creditor that the loan will be repaid either by the borrower or in the event the borrower's failure by the guarantor. However, unless the specific terms of the loan agreement explicitly assigns the guarantor a more active or equal role in the repayment process, the guarantor's liability arises only after the borrower defaults, although the guarantor's liability is co-extensive. In the instant case, no such loan agreement has been filed by either party, leaving the exact terms of the petitioner's liability as guarantor unclear. Without these terms on record, it cannot be assumed that the guarantor has any immediate right or responsibility to intervene in the auction process initiated after the borrower's default. As far as the contempt petition is concerned, uh, it is filed by the petitioner against the bank for violating this court's order dated 13/9/2021 in WPC number 26724 of 2021. The petitioner argues that the bank proceeded with the e-auction of the secured asset despite the direction of this court. After examining the pleadings and the bank's so cause reply, we find the petition does not have merit for the following reasons. Based on the discussions as above, it is clear that the OC number 2 and 3 bank acted in a diligent and lawful manner throughout the proceedings. The petitioner's assertion that the bank willfully and deliberately violated this court's order is unfounded. In view of the discussions above and the availability of an alternative statutory remedy, this writ petition is dismissed as not maintainable. However, the petitioner is at liberty to pursue the alternative remedy available under the SurfaceAI Act if so advised. It is made clear that you have not expressed any opinion on the merits of the case and all the issues are left open to be asked before the competent authority as per the SurfaceAI Act 2002. Also stands disposed of. There will be no order as to.
I agree. Yes.
And filed a IA, Your Lordship, to restrain the respondents not to alienate the property, not to sell the property, Your Lordship. They have already property has been alienated.
It is not possible. Tomorrow there is only vote for half an hour. It's not possible.
Criminal appeal for bail, Your Lordship.
After.
Position matter. Position matter.
मुझे
Position matter.
after पूजा और
Petitioner is a widowed lady who is an occupant of Millard's.
Would ask to take instruction from the NHA.
Mr. Das.
Yes.
The homestead of the petitioner has been demolished forcibly by bulldozers and without notice, without Millard's any intimation, nothing.
These demolitions are carried on by the authorities, my lord, on the basis of the provision incorporated under the 2002 Act. It is not NH Act or the NHAI Act 1988. Because in those two acts, my lord, there are provisions relating to identification of national highways and for maintenance, operation, and construction of national highway are concerned. No enabling provisions are there in the hands of the NHI authority to remove the unauthorized construction carried away or by in the form of hotels, subrooms, or residential house. That's why 2002 Act was introduced in the name of National Highway Land and Control Act 2002. A writ application was filed before the Honorable Supreme Court regarding the implementation of the provisions of 2002 Act. I will draw 2-3 orders, my lord. Order dated 20th February 2024, my lord.
Can I have a copy of
Yes, yes, yes.
Thank you.
20th February.
Yes, ma'am. Page mark on this. 8 page.
Page 8.
8 number, ये number serial number for release.
Page 8.
Yes. 20th February 2024 हो गया.
Para?
Next page, my lord.
Para 2.
Yes, para 2, ma'am.
Yes.
In our order dated October 2023, we find flag the issue of implementation of the provisions of the Control of National Highway, Lane and Traffic Act 2002 or sub 2002 Act. The affidavits have been filed on record, which only indicate that the various authorities, as contained by Section 3 of the 2002 Act, have been constituted or appointed. There are very important functions entrusted to the highway administration. One of these provisions of occupations of highway land, Section 24, removal of unauthorized occupations from highway, Section 26, recovery of cost of removal of unauthorized occupation and fine imposed, Section 27, to regulate right to access to highway, Section 28, and regulation of traffic on the highway when situation contemplated by Section 31 arises. Firstly, we find that there is no machinery created to carry out survey of highway under the jurisdiction of the various highway administration to ascertain whether there are unauthorized structures or unauthorized occupation of highway land. If survey is regularly carried out, the highway administrations will have no source of knowing whether there is any unauthorized occupation of highway land. Judicial notice will have to be taken of the fact that different parts of India there are unauthorized encroachments on highway land. Under Section 31(2) of the 2002 Act, it is provided that the highway authority must step in when highway become congested or unsafe for vehicular and pedestrian traffic. There is no machinery provided to the citizens of the to complain about the unauthorized occupation of the highway land, congested or situation contemplated by subsection 2 of Section 31 of the 2002 Act. There is no grievance redressal mechanism created for the benefit of the citizens. Unless such grievance redressal mechanism is developed and wide publicity is given to the existence of mechanism, the citizen will not have any opportunity to lodge complaint with the highway administration. Moreover, by some method, periodical survey of the highway under the jurisdiction of highway administration has to be carried out with a view to ensure that the highway are kept free of encroachments. After reading the affidavits of the highway administration, one gets an impression that the machinery is available only on paper. There is no effective implementation of the provisions of 2002 Act. We direct the administration to come out with a scheme which will provide a regular inspection of the highways, for establishment of grievance redressal mechanism, and for taking prompt actions on the basis of the complaints. After carrying out survey, the highway administration will have to exercise the powers under Section 26 of removal of unauthorized occupation so that the highways are clear of encroachment. We grant time 2 months to the various highway administration appointed in terms of Section 3 to report compliance. The role of Government of India doesn't come out and end after appointing various highway administration. It is the duty of the Government of India to ensure that the highway administration functions effectively and discharge their duty under the 2000 Act. The petitioner appearing in person makes a grievance that there is non-implementation of the provisions incorporated by way of amendment to the highway administration rules in the year 2019. The affidavits of the compliance to deal with these aspects. We grant time to the highway administration to do so or on or before 22nd April 2024. List it on 30th. Then next page, my lord, 30th April order, my lord.
30th.
30th April.
April 2024, my lord. May I place, ma'am?
Yes.
We have perused the affidavit dated 22nd 4/2024, filed by the Ministry of Road Transport Highways, Government of India, reporting compliance with the directions contained in the order 2024. Sri Grant Prakash, petitioner in person, has many grievances to make out the implementation of the direction. Before we go into the grievances, after perusing the affidavit, stated compliance affidavit, we propose to issue additional directions. The letter dated 18/3/2024, addressed by the Ministry of Road Transport, Government of India, records that the teams constituted as per the communication dated 18/3/2020 will carry out frequent inspection of the national highways for ascertaining existence of encroachment on the highways. Certain steps incorporated in Annexure A by 5 to the compliance affidavit. Prima facie, we are not satisfied with the action taken as reflected from the said statistics when it comes to removal of encroachment on the highway as provided in section 26 of the Control of National Highway Land and Traffic Act 2002. To test the stand taken in the compliance affidavit, we direct that a specific affidavit shall be filed, placing on record the details of the inspection carried out on the national highways and actions of removal of encroachments taken on the highways in the state of Assam, Gujarat, Karnataka, Maharashtra, Rajasthan, Tamil Nadu, Uttar Pradesh, and West Bengal. We direct the Ministry of Road Transport to collect the data of the inspection carried out by the inspection squad, the action of removal of encroachment taken in these states up to 30th June 2024, so that we will be able to issue further direction. A compliance affidavit on these aspects shall be filed by the concerned respondents by 26 July 2024. From the perusal of the chart at Annexure A by 5 affidavit, it appears that though notices have been issued right from April 2023 as regards large number of encroachments on the highway, actions of removal appears to have been taken in respect of few structures occupants. The Ministry of Road Transport and Highways will invite attention to the concerned state to this aspect. We will make it clear that wherever for taking action under section 26 of the 2002 Act, assistance of the local administration and local police is required. The same shall be rendered by the authorities of the state. The Minister of Road Transport will forward a copy of this order to all the concerned revenue and police authorities of the state. As regards the paragraph 8 dealing with non-compliance of the provision incorporated in 2002 by 2019 amendment, the Learned ASG states that there is an inadvertent mistake in paragraph 46 of the affidavit. Sri Gyan Prakash, petitioner in person, points out that pursuant to the amendment made in 2019, rules were framed, but there is no reference to the rules in the affidavit. At this stage, the Learned ASG clarifies that there was amendment in the year 2019 to the Highway Administration Rule 2004. We direct Ministry of Transport, Road Transport and Highways to collect data regarding implementation of the rules as amended in the year 2019 from all the states and file a better affidavit dealing with compliance with the state rules. There are a large number of issues involved in this petition. We must record our application for the persistent effort made by the petitioner, Sri Gyan Prakash, to ensure safety of our national highways. However, we will need assistance of a member of the bar. We therefore appoint Ms. Sadansa's learned advocate on record as amicus curiae to assist the court. The registry to provide soft copies of all the documents on record and pleadings. We request the learned amicus curiae to interact with the petitioner, Sri Gyan Prakash, before the next date so that she can render effective assistance to the case. List it on 2nd August. On 2nd August, it was deferred to 27th next page, 27th August 2024. List it on 27th. And 27th August, order next page. Ms. Swati Gildia, learned amicus curiae, has pointed out that a circular dated 18/3/2024 has been issued by the Minister of Road Transport and Highways, Government of India. Our concern is that if the encroachment on national highway are to be prevented and removed, proper inspection team must be constituted for regular inspection of highways. She pointed out that the inspection frequently laid down in the circular dated 18/3/2024 is the same as prescribed in the construction stage. This will not work. Therefore, we direct the Ministry of Road Transport and Highways to constitute proper teams for frequent and regular inspection of all the national highways to ascertain whether there are an encroachment. Each team shall be made responsible for a particular stretch of individual highway. Secondly, a mechanism should be created to ensure that the inspective team, after finding encroachment, immediately report to the competent authority empowered to remove encroachment. The ministry shall also develop a portal where citizens can lodge complaints about the encroachment on highways. On the portal, citizens should be able to upload photographs and location details of the enclosed portions. Moreover, a facility must be also created of a toll-free number to enforcement. Action taken report based on the complaint shall also be uploaded on the portal. It is also necessary for the ministry to give wide publicity about the availability of facility, portal, and toll-free numbers on all the national highways and in the media so that citizens are made aware of the facilities existence. We grant time till 30th September to the Government of India to implement the above direction. We grant time 1 month to the learned amicus curiae to prepare a note on various issues which arises on which the direction of this court are necessary. The notes shall be provided by the learned amicus curiae by 30th September 2024. We direct the Ministry of Road Transport to place on record the details of the action taken in terms of the circular dated 18/3/2024. The data shall be placed on record in the form of an affidavit within 3 weeks from today. The petition shall be listed on 14th October 2024 for hearing of the parties and issuing interim directions. We may also clarify that the mechanism made available for the national highway must be extended to the state highways. We propose to issue necessary direction on this behalf on the next day. There is a committee set up by this court dealing with the issue of road safety headed by Justice Abhay Sapre, a former judge of this court. The issue of enforcement on highways has a nexus with the road safety. Therefore, the registries are forward copies of the order which may be passed hereinafter to the said committee. Here, several other persons have approached the Honorable Court because the petition shall be listed on 14th October for hearing of the parties and issuing interim direction. Because there is some landowners, they have filed petition that their cases have not been properly dealt or there is excess demolition. That's why they have filed an appropriate application before the concerned court, my lord. Here, my lord, after this order was passed, my lord, as per the 18/3 order of the central government, my lord, the committee was constituted and the direction were issued by all the chief secretaries.
Can I have a copy? Thanks. काम करा बेटा extra copy be given to us at least.
Yes, sir.
We can also peruse what is being placed before your lordships.
This is the document, my lord, where as per section 3, the project director of National Highway, paragraph 2, my lord, next page. The project director of National Highway Authority of India and then the general manager or the deputy general manager of the National Highway Infrastructure Development Corporation and the executive engineer of the National Highway wing of the state public works department shall exercise power and functions of the highway administration conformed in section 24, 26, 27, 30, 33, 36, 37, and 43. That is pursuant to section 3 of the 2002 Act. That there must be an establishment of highway administration. That notification was there. Project that has been entrusted so far as national level and as per 20th 2024 order that I have given also.
Yes.
Road Transport Department is given as per the order dated 20th February 2024. First order I have placed, madam. Compliance order passed by the Honorable Supreme Court of India on 20th February.
Which one you are placing?
Providing support to the state government.
Which one you are placing? 10th April 24.
10th April 2024.
Yes.
Yeah.
Compliance of the order passed by.
So after that order, my lord, this communication was made by the central government to the chief secretary. And my lord, next page, my lord, the government has given a letter to the
Collectors.
Chief General Manager NHAI, my lord. 30th April, my lord. And then next, my lord, on 13/6/2024, my lord, all the collectors were directed to comply the order direction of the Honorable Apex Court, my lord.
Copy got something I'm paying. The copy next. I'm left without a copy.
Yes, so this is the Chief Secretary's letter to all the collectors. And it is dated in compliance with the order dated Swan Suaksha.
Two times.
Yes, sir.
Let me also have an opportunity to go through this. Without a copy to me, my lords, all these things have been placed. I don't.
You will give it, just he's facing you.
Your lordship is referring to it.
Just this Mr. Das.
Yes.
If you come to the paragraph number 8 of the writ petition.
8 of this.
Writ petition.
Yes.
That is precisely the point. The entire.
Just. So he has given that this is the khata number, plot number. Then
Yes.
He has mentioned the National Highway Authority.
Yes.
On 29/8/24 and 31/8/24, without any reason and issuing any prior notice to the petitioner, has run bulldozer over the individual residential house and business space of the petitioner, both of which were constructed fully within Swanso. Now you please come to the Honorable Supreme Court's order.
Yes.
The Honorable Supreme Court passed the order on 27/8/2020.
Yes.
And the second page of that,
Yes.
it reads like this: therefore, we direct the ministry so and so to constitute proper teams for frequent and regular inspection of all the national highways to ascertain whether there are encroachment. Each team shall be responsible for a particular stretch of individual highways. Secondly, a mechanism should be created to ensure that the inspecting team, after finding encroachment, immediately report to the competent authority empowered to remove the encroachment. Ministry shall also develop a portal where the citizens can complain about the enforcement on the highways. On the portal, the citizens should be able to upload the photographs and location details of the encroached motion. Moreover, a facility must be created so and so to report encroachment. Action taken reports based on the complaints shall also be uploaded. It is also necessary for the ministry to give wide publicity so and so in the media. So this is the direction which was issued 2 days back.
Yes.
Prior to that. So how within these 2 days you verified you formed a team and that verified found to the conclusion that this is the in fact enforcement has been made, and that is why the action is to be taken. Because even if that team is constituted and they find the encroachment, they are to report it to the competent authority. They cannot themselves do it. So thereafter, this is procedural.
Thereafter, 26 is to follow.
This.
Thereafter, section 26 is to follow. Notice is to be given. I have to be heard. It's an opportunity of hearing.
So
this order was passed, my lord. This order was passed. 27/8 order was passed, my lord.
Yeah.
For the second time, when the amicus query stated that the procedure is not correct, because it will not give. Because earlier,
no, prior to that also they stated
yes
that because it cannot be said that there is encroachment or not, so let it be regularly verified.
Yes.
You just come to that.
Yes. 30th April.
Yes, that is 30th 4. 34/2024 order if you comes, then paragraph 3.
Yes.
The court expressed that prima facie we are not satisfied with the action taken as reflected from the said statistics when it comes to removal of equipment on the highways as provided in section 26
Yes.
of the control so and so.
Because the annexure A by 5 doesn't reflect much demolition of the existing structure.
Now you see the paragraph 4. To
Yes.
test the stand taken in the compliance affidavit, we direct that a specific affidavit shall be filed placing on record the details of the inspection carried out
Yes.
on the national highway, the actions of the removal of and so on so taken in the highways in this so and so. Of course, it does not relate to Odisha.
In respect of others.
Others.
States, madam.
But the question is that when in respect of one state, it has been indicated like that, and you are removing a person, you are just going on demolishing the, so you should have been very careful that reasonable opportunity as provided.
Absolutely.
It should have been granted. There should have been proper measurement.
Yes.
And measurement should be in presence of the parties, not that you come and it's
Yes. Here is a case, my lord.
Land.
Here is a case, my lord. They have received compensation in lieu of compensation.
In 2000,
When that land was lying vacant, my lord, taking opportunity that this land was not by the NSI, they have again constructed over the said.
find a detailed
I don't think my learned friend, Manoj, I would take exception,
My lord, what was held on that day, my lord?
strong exception to his submissions. Lakshmi, kindly,
My lord, let
you
me
have not filed
particularly
the authority. It has no, even notice has not also been issued.
it has not been issued.
balance the
What has happened, my lord? NSI on that day, when they reached the spot, my lord, the petitioner approached them. You just identify. They make a goal.
No, there are two things. First of all, according to as per the amendment in the writ petition,
Yes.
if at all it is true that this notification was in the year 2010 and opportunity was called on from the parties to give their replies. Basing on that, if you insist that yes, the compensation has already been paid and the building has come thereafter, taking advantage of the travel land, in that case, the building plan must have been there. All these things must have been or authorized or not.
That's why.
these are all submission of the top of the head.
An isolation.
Yeah, Lordship may see,
100 case of that area has been demolished.
I am concerned about my homestead.
On the
So
basis.
Lordship may kindly, Lordship, I've never argued like this. No, the homestead land, Stithiban land, the patta has been modified,
No.
rectified patta, we have reduced the land.
Let's file the counter affidavit, it cannot be adjudicated.
That's right, your Lordship.
All right,
I mean-
notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Amitabh Das, Land Council, appearing for the NHI, files some orders of the Honorable Supreme Court passed in on such and such cases. So also the instruction issued by so and so to the these are all taken on records. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. You are appearing for all the opposite parties. Mr. Das, there
It
are
would be
two
appearing
opposite
for-
parties. One is appearing for both. Second is also collector.
Collector, I don't think he will appear.
Appearing for opinion one.
Collector, I think the state council.
Right.
Don't state council appear.
Das appears for opposite party number 1. He has already received the copy of the writ petition.
Number 2 has to be stated.
2 and 3,
2 and 3.
Land Council for the state accepts notice on behalf of opposite parties number 2 and 3. Let extra copies of the writ petition be served on such and such date. Put up this matter with a date after Puja holiday. Counter affidavit, if any, be filed in the meantime, giving copy thereof to the for the petitioner. All right.
There's an interim prayer, Manoj, your Lordship may kindly come to the.
Interim is already been demolished.
No, I want to, this is my home. Lordship may kindly see, look at the predicament, Manoj, my house is wide open. Lordship may kindly come to page 37, annexure 6. And ladies are there, children are there, Manoj, the wild animals can get in. I want status quo, Manoj.
It has already been demolished.
Already demolished.
Now, this is the way it will remain till he files the common arm. It's my homestead land. My land staying there.
You cannot further construct anything.
Let me close that portion.
That will demolish. But that half demolished.
After.
Yes.
Lordship may at least maintain status quo manners on this.
That will. 14 times have been listed before the honorable apex court. Let them approach the court.
All I don't see that.
Why should you demolish illegally or approach the apex court?
Yes, item number 3.
And just now your lordship has delivered the judgment on this issue.
Alternative application remedy is available.
My only chairman that if your lordship will allow the person to make a repentation, which will considered by the bank. That's
The petition is also at liberty to make a representation before the bank. It is up to the bank to consider the same in accordance with law. Yes. Mr. Malik. Okay, Mr.
Item 4. Now, please, Lordship, my witness appeals me to continue possible.
Annexure 2 is the
Yes, ma'am.
annexure 2 to the
Item 5.
Item 5 is permitted to withdraw millers.
to
Lordship, grateful.
next.
I am submitting the memo.
Item 6.
Restrictions to appeal to the bank.
Action.
Item 5.
Yes,
Now
Thanks.
appeals for the bank. You are filing a memo just.
Yes, ma'am. I have already
Filed.
filed. Yes,
of withdrawal decision.
yes, grateful.
Okay.
Item 6.
And 6 pass over. We have
No pass over. It will go after. Yes.
Item 7.
OGS matter the deposition pending millard.
Covered matters
Similar order.
pending to be
କେତେ ଡେଟ୍ ଅଛି?
Similar order.
7 ରୁ 12.
Aଜ୍ଞା.
Okay. ଦିଅନ୍ତୁ ଗୋଟେ. Yes, next.
Item 13.
What modification you want, Mr. Mahanti?
it's a modification for order dated 24/9.
What modification?
In part, Tahsildar com land action body instead of Tahsildar com land action Jajpur. Jajpur is a body of
କରି ହବ
again.
paragraph 6 ରେ
Para 6
ଯୋଉଟା ଅଛି
twice mentioned
last line ଅଛି
Dithore is twice mentioned.
ମଝିରେ ବଡି ଲେଖା ହେଇଛି ତ ବଡିରେ
Para 6 ରେ para 6
para 6 ଲେଖା ହେଇଛି
twice mentioned Dithore mention ହେଇଛି body Jajpur ବୋଲି. ଏଟା body ହବ first sentence and last sentence.
ହଁ ଯାଜପୁର ହେଇଛି ସେଟା ବଡି ହବ
body ହବ.
ଆଚ୍ଛା ଏ ଯୋଉ ତହସିଲଦାର from land acquisition ଯାଜପୁର shall be read as ତହସିଲଦାର from land acquisition officer ବରି ତ
ଦିଥର ହେଇଛି
ହଁ ନାଇଁ ବଡି ଆପଣ 4 ରେ ଲେଖା ହେଇଛି ବଡି 6 ରେ ଲେଖା ହେଇଛି